to order at 5:50 p.m. Roll call, Mr. Bailey is absent. Mrs. Dean is absent. Mrs. Johnson is absent. Mrs. Martin.
Here.
Ms. Miller.
Here.
Mr. Osowski.
Here.
Chair is here. Mr. Barajas.
Here.
Thank you. As per usual, please place all cell phones on silent. And we will then need to amend this agenda because we will not go into closed session. So can I get a motion to amend the agenda to eliminate action item A1, which is closed session? We need a supermajority to do that, and we do not have that.
Support.
Move, oh, okay, wait.
Sorry.
It's okay. Moved by Ms. Miller. Who was my second? Jeff.
Yeah.
Okay. Seconded by Mr. Osowski. All in favor say yes.
Yes.
Opposed? Motion carries 4-0. Okay. Presentation, Section 31AA Funds. Adam Baylock, Attorney Miller Johnson, welcome.
Good evening, and thank you for having me this evening, Board of Education. Before I get into it, because I've got about a 10 or...
Sorry, since we're doing this
okay.
all at once.
So I've got about a 10 or 15 minute soliloquy that I've used as I've talked with various superintendents and boards about this topic. But before I get into that, I want to emphasize that my primary purpose for being here tonight is to talk to you and answer your questions. And so I don't want you to let me ramble on uninterrupted. If you have a question, please raise your hand, interrupt, ask the question. I don't want it to get lost because at the end of the day, the key goal for tonight is to, as far as I'm concerned, is to make sure that our superintendent has guidance on next steps. And so before I get into it, I do want to say that I think tonight has been made easier based on changes over the last business day or two. So on Friday, there was a big change with respect to what's going on with Section 31AA and the ongoing litigation. On Friday, the Michigan Department of Education, State of Michigan, and the plaintiffs in the ongoing litigation agreed to a change in schedule as it relates to that litigation. So what has changed is that school districts are still required to opt in to accepting Section 31AA funds by December 4th at 11:59 p.m., but they will be permitted to rescind that election until December 30th at 11:59 p.m. And so what that has changed is that my recommendation for all of my school districts now is to accept the funding, and then we still get to deal with the thorny question of what to do if there's not a change in the status quo before December 30th at 11:59 p.m. And so much of the conversation that I'm having with boards and superintendents right now is the same that I would have had a week ago before this change, because most of the boards that I work with are not planning on meeting after December 19th, which is when we are anticipating that there's going to be resolution in the litigation. And I say anticipating because it's not certain. And so ultimately the goal, whether it's tonight or at a future meeting before then, is to give the superintendent adequate guidance on what the board would like to do if there is no change in the status quo. All of the boards that I've talked to have indicated that if this waiver of privilege issue is dealt with in the litigation, it's severed, it's no longer an issue, that they'd like to accept the funding because, you know, $140 a kid is $140 a kid. But there have been a number of districts that I've worked with that have expressed consternation at this idea that they would be required to waive privilege. And so that is my goal for the night, is for us to have some clarity with respect to what the superintendent should do if there's no change in the status quo by the time that our last meeting in December is scheduled and resolved. So without further ado, I'm going to go into the issues, if that's all right. So first, as I've already mentioned as part of my discussion tonight, is the Section 31AA of the State School Aid Act imposes a new and novel requirement. That requirement is that in order to accept funding, the school district has to agree that it will comply with a comprehensive investigation that's independent from the school district appointed by the governor, and affirmatively agree to waive any privilege that may otherwise protect information from disclosure in the event of a mass casualty event. My understanding is that this language is coming directly from the governor. And the reason for that is that there are a number of families after the Oxford shooting that were unhappy with the district's response. And that was notable because in about 2 years ago now, there were a number of news articles in the Detroit News where even board members indicated that they were unhappy with the invocation of privilege by the school district. And so this legislation is in response to that. And I think that that's important context because it tells us why we are in this situation right now. The next piece that is really important to understand, I think from a consequences of the decision perspective, is the definition of mass casualty event, because that is the triggering language where the governor would potentially have authority to appoint this independent investigation. And while it's clearly intended to target school shootings, it's broader than that. And I think that that's an important thing for every board and administrator to know. So it means more than just school shootings. It means an incident that results in significant injuries to not fewer than 3 individuals. And so the prominent example that I've used and I've heard others use as we've had this discussion is it could involve like a serious bus accident. It could also involve maybe a fight after a football game, or if you've got stands that collapse. All of those things are things that could potentially be deemed mass casualty events under this definition. With some of my more rural districts, one of the primary concerns has been there's this additional definition there that talks about a sudden and timely surge of injured individuals necessitating emergency services or exceeding the normal resources for emergency response available in the jurisdiction. I think that's going to be less of an issue here than it would be with some of my outstate districts, although I see some disagreement.
You'd be surprised. I mean, we're a small township with a small police force and a small fire force, right? So I had to have my husband taken to the hospital via ambulance. It was a Dearborn ambulance because there wasn't a Redford. So we've now stepped outside the resources of Redford Township, right? So you wouldn't think that it's an issue here, but it potentially could be because if the 2 ambulances that the township has are already in use and we need 1 kid or 3 kids to go by ambulance, we're now reaching out to Dearborn and Livonia and Detroit for assistance.
So that is an instance where, under the strict terms of the definition of the statute, it could cause or could permit the governor to invoke this language and appoint an independent investigation. And so I share that so that you are aware of the breadth of what this could mean. Do I think it is particularly likely that the governor would invoke this in that circumstance? No. But it is a possibility and one that you should be aware of before you make a decision.
And a future governor
And a future governor.
could invoke it, right?
Yeah, I also see it as a student suicide. So that in that case, that's 1 person.
So, and that's because one of the components in the definition is it says fatalities. There's no numerosity requirement. So it doesn't say fatality or fatalities. And so there are circumstances where I think it could be interpreted that way. Again, do I think it's particularly likely? No. But I do think it could be interpreted that way by someone. And with a different governor or a different political status quo, that could be an issue that we would run into.
And so as we think about student suicide, maybe this may not even happen at school. This may happen at home.
I think it's possible.
No, I'm just,
Yeah.
because this is, I work in social work. That's my primary. So that's why that has me going,
Concern, right?
Thinking.
Yeah.
I will say that the definition of mass casualty event generally tracks the definitions that I see.
Yeah.
But in this context, with these authorities, it's broader than I feel like it's intended to target, right? So again, all of this important information, because at some point, the board here is going to be asked to make a decision. And part of the reason that I'm having this conversation with boards leads me into my next point, which is, why are we in front of a board for this? Because typically we don't bring grant applications to the board. And the answer to that is because of this waiver of privilege concept. In my view, and I know I've had discussions with some of you individually over the last couple of years, privilege is held by the board, and there are complicated issues that come along with that. And so in my career as a school attorney, have always taken the position that the board needs to waive its privilege and that it can't be waived by an individual unless there's been some delegation of authority. So it's possible for a board to say, hey, you superintendent can make that decision. But as a general rule, that's not how I apply these things and it's not how I look at them. And so I am very much of the opinion that a board needs to make the decision that would waive privilege, which is why we're in front of us. And to the extent that the district decides that it would like to accept this grant money, I would suggest that board action is required. I don't think that's true on the other side. So I think the board could decide, not decide, but there could be the decision that the district is not going to pursue that money, in which case I don't think it takes board action to say no, just to accept the money because it requires that waiver of privilege.
Could the board action, or the resolution of boards across the state saying no, send a message? You know, a lot of times, like K-12 Alliance will ask us to pass a resolution. And so maybe if enough boards actually pass a resolution that says no, they'll get a clue. I mean,
I
one
think,
can only hope.
I think that there is some value there, but I think that because there's ongoing litigation that's been signed on to by a large number of school districts and superintendents, that message has already been sent.
Okay.
So I don't think that there's any additional value that we would get out of having a resolution that says no,
Okay.
that isn't already encompassed by the litigation that's going on right
Okay.
now.
Figured. Mrs. Martin,
Darn it.
I distracted you.
So now, because this in total is like $140,000.
So it's $140 per student.
140. Oh, person.
And given, so it's funny, is a week ago I was giving slightly different guidance because there were a number of large school districts that had indicated that they were not going to take the money. At least that I'd heard through the grapevine, even if I don't necessarily represent them. That has changed now because of the change in the litigation posture. So what I'm suggesting to everyone right now is you should plan on, if you accept the money, it's $140 per kid. And it may be more, but you should plan on it being $140 per kid. Just based on the overall structure of the litigation right now.
And now, as it relates to the litigation part, it's basically saying you're given till the end, like what is it, December 31st?
December 30th at 11:59 to rescind the decision.
And that's based on, it's like, so I guess more conversation around what that actually means. So like we're waiting on to see how litigation works out, to see if they're going to, what is it, what does it entail, I guess, is like what they're talking about.
So there are two lawsuits going on right now. One filed in federal court by superintendents across the state, and another that's filed in the Michigan Court of Claims by school districts and superintendents. And there are different challenges to the legislation. What I would say is that I am hopeful, but neither case is a slam dunk, is what I would say.
What's being challenged? What are they challenging, I guess?
So the federal court case has a number of challenges to the constitutionality of the language. And so the issue that I have, or the skepticism that I have, is I think there is a way to read the statute in a narrow way that would resolve that case in my view. The Court of Claims case is challenging the legislation on state law grounds based on some kind of archaic constitutional concepts that are found in Michigan law that I candidly am not an expert on, so I don't want to speak too much on them. Ultimately, though, and this is my spidey sense, right? I'm not intimately familiar with the arguments, and I'm not part of the briefing, and I haven't been part of the calls at this point. But what I said at the outset, that I'm hopeful but not overly optimistic, is kind of my stance on it. Is that my gut tells me that, as gross as I think that this legislation is, I'd say it's probably lawful. Although I'm hopeful that the Macomb folks will ultimately prevail, because I think that that's better for school districts.
So basically, are you saying that they're fighting to waive the privilege? I'm trying to see, is that the issue that
So
they're
they
fighting
are
on?
challenging the requirement under the law that school districts waive privilege to receive
That's
this
what
money.
they're.
So they are,
Yes.
so I'm
Yes.
sorry, I didn't totally understand your question. They
Yeah.
are challenging this waiver of privilege requirement.
Okay,
And we will see if they're ultimately successful.
so, but the thought is that the courts may come back by December the 30th.
So it is not written down anywhere, but there's been a request from from all the parties to have a decision by no later than December 19th, and the courts have indicated that they will do that.
That's nice.
So what I would say, though, and this is part of the conversation for trying to give guidance to the superintendent before then, is that unless you want to have a special meeting after December 19th, we should give our superintendent guidance on what path we want them to take with respect to rescission so that they know
So we could pass a resolution directing her.
to rescind or
to
not rescind
Based on the outcome of litigation.
based on the outcome of litigation. And that is perhaps the ultimate goal for where we need to get, whether it's tonight or in a future meeting. But I say all of that in order to give context to the timeline, is that while we may not necessarily need to reach resolution tonight, we will need to in short order, in order to give appropriate guidance.
So it would look something like if we choose to opt in, we give it till like December the 20th. I'm just using that date to say if we don't know by December the 20th, then we don't opt out. Something like that.
Something like that. Or what I would suggest is something that gives the superintendent appropriate authority to make that rescission, based on the conversations that have been had by the board. And so that may take some polling by the superintendent later on, because candidly, we don't know exactly what's going to happen with the litigation. So I would suggest that maintaining flexibility based on the overall tenor of the board and the conversations that the superintendent is having with board members makes a lot of sense to me. I think that most superintendents are going to know where a majority of their board sits on this issue by then. And so I would suggest that they give them the appropriate authority to make that decision.
So, can I say something?
Yeah,
So
absolutely.
I was sat in a meeting today about this, and I don't know if we mentioned that we have to accept it by December 4th. We have to make that decision. If we're gonna accept it, we have to do it by December 4th. If we don't, then we're out. And then the other thing that I heard today, and I don't know if this is something that you have heard, but they said maybe not December 20th, make that decision if we don't get what we're hoping to get, but give it a little bit of time because they may start filing some more
There will almost certainly
things
be
right after, within
appeals.
like 24 hours, they said.
There will almost certainly be
So you almost
appeals.
want to take it till that deadline.
You're going to want to take it all the way to the
December
30th.
Um,
Not that I would suggest waiting until 11:58,
No.
but we will have better
11:55.
indications.
And Adam, can I just ask, only because obviously this is out
They did.
of my realm, how do we choose to opt in and opt out? What are,
It's in.
So
Nexus.
the opt-in
Nexus, okay.
is in Nexus.
Okay.
And then the very lawyerly, you will rescind in the form and manner as developed by the departments,
So
which is,
understand,
we don't know yet. But the department is going to do something that will allow us to rescind,
So they'll give us
some kind of guidance.
guidance, okay.
When you say
I'm-
department, what do you mean, DE?
MDE.
MDE will give
I'm
us.
expecting some kind of form that needs to be
So,
submitted via
we
email.
don't even- I don't- For me, I'm always erring on side of caution, so it's like, let's say for instance.
They have promised to
They
give this,
promised,
right?
they said, but they may not.
They have stipulated in a court order that they will.
Okay.
So I am, they are going to do something.
Right.
They are going to do something. I don't know exactly what it's gonna look like. At 6:09
And do
on
you
November
think-
24th.
right. And I can't imagine that they'll make it easy.
I don't
know.
think
Maybe
they're gonna
they
make it
don't
hard.
maybe they don't wanna poke the tiger.
And I will be
It's a
candid,
matter of checking
A bunch.
I'm expecting a checkbox.
Okay.
I'm expecting something easy, and part of that is, I think MDE actually doesn't care about this. I think this is the state of Michigan.
Of course.
And you
This is
notice,
Dana Nessel has
they-
her panties in a bunch because Oxford said, no, we don't want you to, oh, I'm sorry. And then the governor got her panties in a bunch. And so,
I note that MDE in the state of Michigan have separate counsel in these cases. So they've got different departments of the Attorney General that are representing them
Yeah.
because I think their interests are different.
well, yeah.
There are a couple of other kind of what I call practical considerations that I think are really important for boards to be aware of as we talk through these things. The first is that the statute as it's constructed talks about the school district. It doesn't necessarily talk about individuals. And that is the basis of the federal lawsuit that's been filed, is that it's ambiguous as to whether or not it relates to individuals. Now, I think it is a natural construction of the statute to apply it only to the school district rather than individuals, but it's a little ambiguous, and that's something that is hopefully we're gonna get some guidance on in the next couple of weeks, as I knock on fake wood tonight. But I note that because it is possible that individuals have not necessarily waived their privilege, because a privilege waiver has to be knowing and voluntary, that after a mass casualty event could invoke their privileges. So I look at a social worker, for example, that has confidentiality obligations, ethical ones for those that you serve. And it is very possible for an individual to be at odds with the district if the district decides to accept the money. And so that's something that is a kind of an interesting nuance that I think is important to know before we make a decision.
So, but, so I think my concern with that is, if they're being represented by district legal counsel, then does their individual privilege apply? Because it's not, like, technically, you aren't my personal attorney, right?
So you have picked up on the issue.
Right. You are Evelyn Pridemore board president's attorney.
So you-
But I mean, we know when I'm acting in this role, we believe that I'm protected under governmental immunity, but that's where my concern is.
So you've absolutely picked up on the issue. And so one of the things that I'm having discussions with individual school leaders about is after a mass casualty event, you may want to procure your own counsel. Because if the district is representing you, I am of the opinion that the district's waiver of privilege would mean that your discussions with district counsel are unlikely to be privileged. Very unlikely under that, if you accept the money. And so for districts that are accepting the funding, I think it is a very real question or concern to say, hey, am I going to procure individual insurance in order to make sure that I'm covered? And so many of the statewide organizations, MASA, MASSP, offer that. I think the elementary principals organization does. But in the event of a mass casualty event, the amounts that are offered are not going to be sufficient. And so that is something that I think is worth exploring for a district leader.
And then are they still protected under governmental immunity?
So the statute does not modify governmental immunity.
Okay.
And so I do think that governmental immunity is going to remain as the primary protection.
Whether they evoke their own counsel or use.
Exactly. There's no modification of the statute here. And so I still think that's going to remain as the primary defense both for the school district as well as individual school district employees in the event of any tort litigation, right? So any lawsuit that there was negligence or whatever it may be. But, and this is one of the practical realities, there's going to be an independent report that's out there that almost certainly points the finger at some school district employee, some staff member, someone that could have done something. Now, that's not going to change much for most cases, but could for some. It's hypothetically possible that it would change the analysis as it relates to governmental immunity, and that report is going to have a lot of weight because it's being done independently by law enforcement or some arm of the government, and is almost certainly going to point the finger at someone because that's the nature of those reports. And that's no knock on the people writing it, it's just that's what they're being asked to do.
Right, right, that's what they're doing.
Please.
I want to know if we can bring in our student rep on this, just to see if they got any feedback and how they feel about the situation. Axel?
Are you following?
We got a lot of words tonight.
It's just very concerning of like what's the government doing, and as a student yeah, like the money helps the whole board, but like what they want to take from immunity and what they want to do politically and what they want to do in situations, that's concerning. Because like most schools, including ours, there have been fights in school, outside of school. That's normal. But are they going to intervene in that, or may they not intervene in that? That's the concern. And there's a lot of stuff that might be going on and stuff that's hidden and they might want to bring out, and it's just very concerning.
Thank you.
So, returning to the governmental immunity question,
Yeah.
I do think that there's going to be some difference on the margins, right? Because
Right.
you're going to have this independent report that's going to point fingers, and so I think the most likely outcome is we're going to see settlements that are larger than they would have been otherwise. Now, the reality is, in the aftermath of Oxford, Tim Mullins and his team were successful as it relates to defending the district from a finding of liability. So there was no district employee in the school district was not held financially accountable for that, although obviously there are a lot of other consequences that came along with a nuclear event like that in your community. And so I don't want to dispel or say that they weren't held accountable, because there were other forms of accountability. But as it relates to legal liability, financial legal liability, they were found not liable for the conduct of Ethan Crumbley.
Does it open our employees up to criminal liability? Because I think what we learned from Oxford is that, I mean, look at how we held his parents accountable, how the courts held his parents accountable. My concern would be that they then say, well, Susie Counselor, missed these warning signs, right? And didn't insist that, parent one and parent two take, student home. And so now Susie Counselor is criminally liable as well for not insisting that the student be removed from the building, or not reporting that this student was in mental distress, or I think my concern would be in protecting our employees from criminal prosecution because they just made a mistake and they missed something. I mean, I think we all can see where you miss something. You just miss the warning signs. And it's a terrible thing. It's a terrible thing. It was a terrible thing that happened, and the warning signs were missed by more than one person, and that's, I think that was, but we're human beings, and sometimes we just don't see it. And that would be my concern, is protecting our employees from criminal prosecution.
Yeah. So
well.
it's impossible for me to deal with all the
You don't have a magic
hypotheticals.
8 ball,
I
come on.
don't have a magic 8 ball. But what I will say is that my understanding in the aftermath of the Oxford is that those kinds of things were explored. Although ultimately, I'm not aware of any school district employee that was held criminally responsible for anything. It's difficult for me to know if a waiver of privilege would have impacted that analysis, because I just don't know. But there are certainly fact scenarios where it could happen. And so I would also say that I think those fact scenarios are probably similar in a non-privileged waived world as well. The issue is, and this is maybe one of the core components that I think is important to understand, is that when we're talking about a mass casualty event, we're talking about an event that is nuclear for a local school district. The whole administrative team is going to change, because that's what happens in the aftermath of those events. And what we're talking about is that in that situation, the insurer comes in and takes control of the situation because they're concerned about liability, which is their job.
Yeah.
And so what we're talking about is losing control over the 2% that's left, right? Or a sliver of the 2% that's left, because you're going to lose control over almost everything in that scenario anyway. And so I think that that's an important consideration too, is that at the end of the day, we're not talking about losing control of everything, because we've already lost control over most of it. We're talking about losing control over some information in what's left. And that's just something that's important. One other piece that is important in my view, and one of the things that's come up on a number of occasions with the conversations that I've had with other boards, is that the money is intended to assist with that as well. And so that's something to keep in mind, is that the money is intended to assist with safety, security, and student mental health. And so it is tough to say no to that, given its focus. And so I think that's something that should be on the board's mind as well. One other topic that's been really important for a number of the boards that I've talked to is the consequences with respect to insurance. So I know, because I've talked with the Middle Cities folks, like the stance of all the insurers is your insurance isn't changing. But I also know that just like I talked about, there's maybe some difference on the margins with respect to governmental immunity. Having an independent report that outlines all the facts is going to make the plaintiff's job a lot easier, right? Because they're not going to have to go searching for those facts. They're not going to have to go through and prosecute the case in the same way that they would have if they had to litigate it. And so I do think that you will see some differences on the margins, right? You will see some differences in the dollars related to a settlement, and you will make the plaintiff's job easier to make those cases. And I've had those conversations with the folks at Middle Cities. They share my views on those things. I'm going through my checklist here. So I've got two more items that I think are important. One is that if a school district accepts the funding, my stance is that you should plan on complying with the investigation. And the reason for that is this. One is that I think it's going to be very politically difficult to try and wage some kind of challenge on the back end, right? And I'm happy that we have the folks challenging on the front end right now because I think it will help us with some guidance. But the second piece is that if you choose not to comply after accepting the funding, the most likely consequence is that the next state aid payment that you get is going to have a deduction that is equivalent to the dollar amount that you've received under 31AA. And so your district would be in a catastrophic nuclear scenario, and then you would be self-imposing a significant funding problem at the same time and create cash flow problems. And so what I would suggest is that if you accept the funding, you should plan on complying with the investigation. And then the last issue that is on my checklist here to talk about is the duration of the waiver, because that's ambiguous. And so there were whispers, and I say whispers because nothing that was ever written down, that this was only going to be interpreted to apply for the duration of the current fiscal year and then the carryover fiscal year. That is not what is in the certifications. It is intentionally ambiguous, and I would describe that as a feature, not a bug. But practically speaking is that if this language gets through the litigation, I don't think it's going to change in a year or two either. It's probably going to stay in the budget for some time.
Even
Forever? I don't know.
without continuance of the funding.
Even if so I don't know what the consequence is going to be there. But I think that practically speaking, I would not be crossing my fingers and hoping that this goes away in a year or two. And so I would recommend considering that, and considering that the stance that you take is one that you're probably going to have to take in future years,
Every year.
and think about it in that context as well. So I know I've talked about a lot of stuff, and we've had some questions, but I've reached the end of the things that I normally talk about in these conversations at this point. And so I'll turn it over for other questions that you may have, to make sure that you're fully informed before you have to make a decision.
Yeah,
For us lay people, what
Yeah.
is the definition of privilege?
So typically, when a school district or an individual talks with their lawyer, that conversation is privilege. And that is the primary privilege that folks are worried about right now. There are other privileges that may apply, but in the aftermath of a school shooting, one of the first things that I would anticipate a board doing is having a conversation with its lawyer to try and figure out what's going on.
probably, yeah, as soon as the police have left the building, probably before that.
I mean, 18 hours to call a board meeting, right? So
Right,
it's-
exactly, within 18 hours of that happening.
So ultimately, those conversations potentially being disclosed is a worry. And it's impossible for us to know all of the facts that would surround that, but the reality is that Tim Mullins and his team did a really good job of protecting Oxford from liability. And folks don't want that. And that's why we're here.
get it, right? As a parent, I would want answers.
Absolutely.
Right? I would, my heart breaks for them. And I can't imagine, right? As a parent, I want to know why. And I would be screaming for answers. And if I felt like the answers I got were smoke up my dress or whatever, I would probably be screaming for, change. It's, you sit in this seat, right? And you have to make a decision based on this, on what's the right thing for this district to do, to protect the district and to protect our employees. But then I can't fathom what they're going through. I can't imagine.
How many students do we have right now in the district?
About 2,500.
Oh, so that's not you.
Yeah, I mean, it's,
It's about 350,000.
right. And just, we talked about how much does this funding really come to for our district? And it's not we're not a big district, it's not millions of dollars, and it's like,
350.
yeah, it's like,
Is it worth it?
right, that was the conversation that we kind of had in the last board meeting was, how much is it really worth? Is it worth that was kind of what led to the board leaning toward not accepting this funding.
And Adam, is it correct? Kim and I were at a workshop last week through Collins and Blaha, but, so the money could be used to pay for safety and security. However, you can only pay for security that is actually employed through a law enforcement agency, is what it sounded like Gary Collins was saying. So you could pay for your SRO because they are employed through your local law enforcement agency, but you can't pay for retired police officers who are working as security guards or just trained security guards. So the funding isn't as,
The criteria on the 31AA funding has changed every year for the last 5 or, it's been in place for the last 5, and so it changes every year. One of the new additions is the idea that you can't supplant, you can only supplement, which is a concept that we hear about most often with our title funds. Although there are workarounds for those things as well, but I don't think there's any disagreement from me as it relates to, I know that SROs are an acceptable use of the funds, but those criteria continue to kind of change year over year.
right. So if we still have to have security in place and we can't use this funding to pay, you know what I'm saying? It's,
Yes.
So, I guess my question is, without this, because we don't have this funding now,
correct?
and without this funding, how we will continue to function as we're currently functioning right now?
Yeah, I mean, it would
What-
help, but
what would help? I was
remember,
gonna ask that.
remember, we did have a mental health grant in the
We did.
past, and we had to cut ties with those employees because the grant ran out. So our mental health clinicians, we no longer employ, which could be reinstituted under this money. But if the grant's only good for a year, and then,
The person will always, it's no job security per se.
right, right.
How
Do we
much
want
was
to get in
that?
the business of hiring people? How much was this past grant?
Yeah, the grant itself.
Kim, do you remember? Because I wasn't really involved in that.
Was it, you think it was more?
I
I
want to
think it
say it was about $300,000, if I'm not mistaken.
Yeah.
Because we used it to pay for 3, we were able to get 4 mental health clinicians.
I think we used some other funding for that too, though. There was 31, there was another grant that we were using
It
to
was
pay for those.
31N.
31N6 or something like that. Was also paying for those, but, where was I going with what I was just about to say? What were you asking me?
How much with the former grant?
Oh, was the former grant. I'm not sure, but we also got carryover too as another part that comes into it. So from year to year, if you don't use all of the funding or it's not all spent, we get carryover. So the number kind of fluctuates as well, because we could have had money from the year prior also last year. So I don't know, but we could find out, but,
So if I can offer what I would say are the two factors that I see most closely correlating with the districts that I work with, right? So there are 2 factors that I think correlate with acceptance or non-acceptance of the money. One is the financial condition of the district. Districts that I'm working with that have lower fund equities are more likely to take the money. Full stop. The second factor that I've seen correlate, and again, it's not 100% by any means, is that more rural districts are tending to decline the funding, tending to say that they're not going to take the 31AA money compared to more urban school districts. And I don't know if that is a proxy for size. It may be, because our more rural districts tend to be smaller, but it's certainly not universally based on size. And so I just offer those as things so that you know where others are tending. But up until Friday, and I say that because that's when things kind of changed, I would describe it as the most even split that I've seen on an issue among school
I
districts.
think even Mr. Bailey said he had attended an MASB training on this or meeting on this, and he, in the room, most of the districts that were represented in that training, they were not inclined to take this funding.
But I would also
But that
question
was
though.
before,
Yes,
before
that's exactly what I was
Friday.
gonna say.
So, I mean, the whole, everything shifted on Friday because, why would they make our lives easy, right?
Right.
Thank goodness that it shifted.
So do you see more districts now, knowing that there's a chance that we could rescind that, okay? Do you see more districts saying, yes, accept it, and then,
What I would say
Hold on
is
for
that
the rescind.
my recommendation at this point is every district should accept.
That's what MASB
Then,
does too.
then the question is, what direction do you give your superintendent with respect to rescinding?
So do we need a resolution with that direction to our superintendent at maybe potentially our regular board meeting?
Maybe. It depends, very lawyerly, it depends.
That's not,
And I don't mean to say that to be difficult, but one of the pieces that I think is really difficult is we don't know exactly what's going to happen with the litigation.
right.
And so there are about a dozen permutations to be like on the low end, right? There are dozens of permutations of what could happen, that it's very difficult to ascertain a particular plan for any particular school district. And so what I would say, and I think I said this earlier during the meeting, but it may have been before, right? What I would say is that if your district is considering rescinding, what I would recommend is you grant the superintendent the authority to rescind, and you let them know and let them work so that they have a good understanding of everyone's different perspectives on that. And some of that may be discussion amongst the board at this meeting, or it may be on the first, or whatever your subsequent meeting is, because unless you're gonna have a special meeting in
The week of Christmas.
the week between Christmas and New Year's.
Yeah. Oh, yeah.
In the 12-hour window that you've got there, where you might be able to get a quorum together and also get an affirmative vote, because you're gonna need at least 4 votes. Ultimately, that decision to rescind is going to depend a lot on the facts and circumstances. Now,
So if we give her direction prior to, we don't need to call a special meeting.
exactly.
Yeah.
And- And so there are, there's a district that I'm working with that I know that if the waiver of privilege is in there, they would absolutely rescind.
Yeah,
And so
absolutely.
so their guidance is very simple.
Yeah.
There are other permutations that ultimately you're gonna wanna make sure that your superintendent has appropriate authority, and then have a good pulse on where the board is on this particular issue so that they can make an informed decision.
Yeah, because I love you all, but I don't really want to have to call a special meeting, December 28th.
Well, and we
as
may,
much
and,
as-
and candidly, things may be changing at that point because there are almost certainly going to be appeals.
Right.
So
then-
I don't think that we can predict exactly what's going to happen on each day at this point, other than we anticipate that there will be decisions at the initial level by December 19th. That's the only thing that I can feel confident saying, because I don't know what will happen after that.
Because my thing is this, we're gonna get a decision, hopefully by the 19th, and we don't know what that's gonna be. And then, let's say, for instance, it doesn't go in favor, then something else gonna drop, some type of other lawsuit gonna drop. And then, that December 31st, we gonna rescind, but let's say for this, well, I'm just saying,
Right.
And then, let's say for instance, if we rescind, let's say for instance, this next round happens and the turnout turns out in favor of what we was pushing before, but now we done rescinded, now we don't get no other opportunity to like opt back in. It's, I don't know. It's just how my mind is going. It's like, are they gonna push the
Yeah,
date?
I think we have to be okay with
Not saying, yeah.
the rescinding. If we decide that we want to rescind, I think we have to be okay with the fact
Rescinding.
that we're not going to get to opt in at a later date, that potentially we're not going to get to opt in at a later date, and that we're going to have to address this issue again next year
Yeah.
because depending on, the outcome of litigation, right?
Yeah.
And that we have to be okay with no matter what happens,
Agreed.
we're not taking, that we are potentially not taking this money this year.
Yeah. Agreed. Thank you for that.
Okay. So I guess I would ask, are there any other questions, or is there any further discussion?
Okay, Ms. Marsaffi? Ms. Miller? You good? Okay. I think we're good on questions. So that would bring us then to our action items. We removed action item number 1. We will go to action item number 2, section 31AA funds. I will read the resolution as it is recommended currently. Currently, our resolution is, resolution regarding the acceptance of funding pursuant to section 31AA of State School Aid Act. Whereas section 31AA of the State School Aid Act of 2025 offers funding to support school safety and mental health, and whereas section 31AA-9 conditions the receipt of this funding on the following criteria: 1, affirmative agreement to be subject to a comprehensive investigation into a mass casualty event; 2, affirmative agreement to waive any privilege that may otherwise protect information from disclosure; and 3, agree to comply with a comprehensive investigation. Now, therefore, be it resolved that 1, this Board of Education, to the extent required by section 31AA-9, hereby agrees to be subject to a comprehensive investigation into a mass casualty event, to waive any privilege that may otherwise protect information from disclosure with respect to the governor-appointed investigation and said mass casualty event, and to comply with the governor-appointed comprehensive investigation. 2, the waiver of privilege is prospective and should not be construed to waive privilege prior to the acceptance of funds pursuant to 31AA of the State School Aid Act of 2025. The waiver of privilege shall be in effect only until the funds subject to 31AA-9 of the State School Aid Act of 2025 are exhausted, or as such later date as may be required by law, and should be narrowly construed to the minimum waiver of privilege required to qualify for such funding. And 3, the Board of Education hereby accepts funding pursuant to section 31AA of the State School Aid Act of 2025 to support school safety and student mental health. So that is the current recommended resolution. So we gotta make a motion first.
Now, Adam, I have a question about the resolution.
Okay.
Yes.
Kim was just thinking about as well. Because this resolution doesn't include
The
a
rescission.
section of the possibility of rescinding.
No, that's
based-
also my discussion.
Right.
We
Yeah.
have to do this first.
So
Okay.
it's moved by
Thank you.
Mr. Osowski, seconded by Ms. Miller, and now we will go to discussion.
Yes.
So currently, it's as presented, and the discussion is,
What she said.
how do we direct our superintendent without having to call a superintendent?
Well,
Because
I
the
was
res-
just because the resolution doesn't say it.
Right.
By December.
And so, earlier today, because,
have a new resolution?
we Miller Johnson put together a new template resolution.
Yeah,
And so I hate to ask you to consider something that you have not had the opportunity to read. I can read it for you, but if you have a meeting scheduled for the 1st, maybe the best course of action would be to consider it next week, because that will allow us to do so and submit before the deadline and also allow full consideration of that.
So we could table this
And present a new
and
resolution
present
for
a
next
new
week.
resolution. Or we could reject this resolution and present a new resolution, correct?
That is entirely up to the board.
What is the will of this board? To table this or just reject this resolution until we have a new resolution, which gives us
I
direction?
reject it till we get a new resolution.
Okay,
That way we
so
have
then
what we're
let's
voting
go-
on. Why table it?
Right, let's go to a vote, a roll call vote. Mr. Bailey is absent, Mrs.
So we gonna
Dean.
say no to this one?
We're gonna say no to this.
Yeah, we can-
Mrs. Martin,
No.
Ms. Miller,
No.
Mr. Osowski.
No. Maybe.
Chair votes no. This motion fails.
We had a new resolution by
We will have a
December.
new resolution at our regular meeting.
Updated.
Updated.
With that will give us some direction.
I don't think I've ever happily had an 0-4 vote like that
Right,
before.
right, exactly.
Just had my first meeting and it failed.
And then, okay, call to the audience. Oh,
Run out of ink on it.
okay, Maria Gaisley.
We'll let you go first.
Well, yeah,
My question is, so do we lose the 31 and
31A.
We no longer have 31N. This is 31AA.
Oh, okay.
This is the new funding for what that was. Then there was some other funding.
We've had this funding in the past.
Yeah.
So then there was that other funding that some of the SEO people that were under.
That was a
called
grant.
No, that was our mental health clinicians. SEL people are funded general fund.
something- Okay, so like the SEO people, I guess my question is right now, the SEO people we have right now, are they gonna keep their jobs if we don't get this funding?
They're not currently funded under a grant, so
So they're just-
I can only speak to this year. But
Okay,
yeah.
so they're funded under our general fund, basically,
Mm-hmm.
is what you just said. Okay.
I don't know if we put, they
Oh, I
might
think-
be under 31A, but
So,
that's money we have every year.
Okay.
Yeah, that's
31
not-
is the half.
Right.
Yeah.
So then, is there other funding we can go after besides this? Or is
Well,
this for-
we have been looking at other funding. So we did receive a grant that I applied for to receive 2 mental health clinicians at the secondary campus. So they're in the process of seeking candidates for that and interviewing for those positions. So we were awarded that grant. And then our elementary schools are still working with Lincoln Behavioral Health to get mental health support. So, when grants come out that we can apply for, we apply, but
So if we're just looking at $350,000, is it really worth it?
Yeah, I don't even think it's that. I think, the last conversation was like 100,000.
140.
Yeah,
I mean, I just read that Detroit's getting 7 million, well, I get it, they have more kids and more schools,
Yeah.
but they got 7 million versus 1,000.
yeah.
I
I
mean,
guess that's the,
how much can you do with 350,000?
right.
For that risk? I don't know,
Right.
just my
I
opinion.
think that's the conundrum here.
Obviously,
it would really come out to about
about this and I was
We
just-
are, like,
3.5
we were
employees
shocked
for
at the
us if we
regular
were to hire.
meeting.
Yeah.
We were like, wait, what?
You could hire how many employees?
Right.
We could
Right.
about 3.5 employees by
Yeah.
the time you add in benefits
And you-
and,
like you said, you can't use it for the
Right.
security guards. we
Right.
have,
Right,
you know, for that.
right.
right.
So-
And then if the funding's only good for a year, you're letting those people go anyway. And the truth of the matter is, it's really, really hard to find them.
Yeah.
So if we were to post and apply now, we might be able to find people by March or April, and then, we lose the funding and we can't maintain it anyway, so.
We lose it, 'cause we didn't, what?
Well, no,
Because
because
you're
it's only a
receiving-
grant, it's
only
only
for a
good
year.
for a
That
fiscal
year.
year.
So, yeah,
Yeah,
I
exactly.
mean, so you're,
yeah.
There's a whole lot of unknown. Okay, so, I will remind the board that this letter with the Miller-Johnson, letterhead is attorney-client privilege, and it needs to be handed in and returned to our attorney, and does not leave this room. And then I will ask if everybody's good, we don't have any further discussion or conversation. Everybody have a great Thanksgiving.
yes, happy Thanksgiving.
I hope it's delicious. I don't know who else cooking, but I'm cooking like my bottom off and working on either side because I'm a retail manager, right? So, Thanksgiving is, All right, future meeting dates, Monday, December 1st, regular meeting, 5:30, right here in the district meeting room. And Tuesday, December 16th, school board workshop, 5:30, again here in the district meeting room. Can I get a motion to adjourn?
So moved.
It's moved by Mr. Osowski, seconded by Ms. Miller. Is there any discussion? Hearing none, all in favor say yes. Opposed, motion carries 6:45 PM.